Welcome back to the Emily Show. This week, I am getting ready to start trial coverage. And if you want to keep up with that, you're going to need to make sure you have the Lawnerd app, free for you, iOS, Android. I'm probably going to tell you about it more later because I'll forget that I told you about it now. But as we cover Sarah Boone gavel to gavel, I'm going to give you a quick overview in this episode of what the case is about. I have not been breaking down every twist and turn because there have simply been too many. This case has been going on for over 4 years, over 9 attorneys, and a brief stint where the defendant was representing herself. We'll overview it. And then there are 6 new civil lawsuits in the Diddy case. His lawyers just responded this morning as I was getting ready to record this. I'm recording fairly close in time to this going live on Tuesday, October 15th, but there's going to be more that happens even when I push end record today. So this case is going to keep moving, but as I shift into trial cover for Sarah Boone, I'm going to try to bring in some of the other cases we're covering into the podcast to make sure that we stay up to date. But if you don't want to miss the quick updates, don't forget to check out Quick Bits on Mondays on the Quick Bits channel and on this audio feed for the podcast so you know all the things that are going on, because I'm still waiting for a date on that new hearing in the Baldwin case. Like the things I want to see happen right now, I am waiting for that hearing in the Baldwin case because I want to see Spiro and Morrissey, and I want to see if the judge is going to charge to the prosecution the cost of defending this motion. I am ready. But before that, we are going to start trial, and I know you are ready for some Lawnerd trial coverage. I think all of us were ready to hunker down for the Baldwin trial to be weeks and weeks and weeks. And then after 3 days, we were all like, wait, what? We're done? Oh, okay. We're done now, I guess. So we're queuing up a trial that looks like it's about 3 weeks long out of Florida. And that's what we're going to talk about first. So without further ado, let's get into it. Welcome to the Emily Show. I'm Emily D. Baker, the internet's go-to legal analyst and big fan of the cursey words. I've been a licensed attorney for over 17 years. I'm a former prosecutor, and I break down the legal side of pop culture and entertainment stories we can't stop talking about. We should just get into it. Let's go. If you're looking for easy solutions for delicious dinners that are using all the flavors of the fall season, look no further than our sponsor, Green Chef. One of the things I realized that I literally never cook unless it is a Green Chef meal are soups and stews. There is something so satisfying about a delicious homemade stew, but I literally would never if it wasn't delivered to my door with easy to follow instructions and ingredients that were fresh. And I got to pick it myself because Green Chef gives you options to meet any lifestyle, including gluten-free or keto or plant-based or protein plus. And they even have more than 15 meals a week that are ready in 25 minutes or less if you're really looking for something on the go. What I love is how easy Green Chef makes it to not only customize meals, but to also pause or change your plan, which we did when we've been traveling a lot this fall, so that I'm not worried that food's going to waste. So if you are ready to find out why Green Chef is the #1 meal kit for eating well for yourself, now is the perfect time to try. Head to greenchef.com/EmilyBaker50 and use code EmilyBaker50 for 50% off your first box plus 20% off your next 2 months. That's code EmilyBaker50 at greenchef.com/EmilyBaker50 for 50% off your first box and 20% off your next 2 months. There's never been a better time to try Green Chef. Let's get back to today's episode. When I say I am ready to get back to
bring the jury.
I am so ready to bring the jury. You know how much I love live trial coverage, and there are some cases that I opt out of due to the nature of the case or just the timing of my life. I particularly opt out of cases with child victims. It is something I chose not to prosecute as much as I could possibly avoid, and something I choose not to cover because I do want us to learn through the trials that we watch. And some of those cases are just so heartbreaking that it's hard to get past the devastation of the case to learn really much about the law because the cases are emotionally so devastating. But the Sarah Boone case is an interesting one because she is an interesting defendant. If you are not familiar with this case, I'm going to give a quick rundown of what we expect to see. I have not been covering this case motion to motion because the amount of motions in this case over the last 4 years is substantial. The defendant, Sarah Boone, was representing herself for a little while by force. Yes, that can happen. And wrote voluminous letters to the court on and on and on. We're going to briefly talk about one of her letters to the court because it kind of lands us where we are now. This case was supposed to start last week on October 7th, but Hurricane Milton derailed the court system in Florida. They were shut down for a couple days. They wanted to make sure it seemed that jurors could also do what they needed to do for hurricane prep, that the court staff could also do what they needed to do for hurricane prep. So instead of starting to pick a jury and then being closed for days on end, they started up jury selection October 14th and are moving through that process now. They are bringing in rounds of jurors. It looks like they're bringing in groups of 50 and then going through and time qualifying them. That means that they're asking jurors, can you be here for 3 or 4 weeks? Because they want to make sure they time qualify jurors for more time than they're going to need. What you don't want to do is say, hey, we're going to be here for 3 weeks and then be there for 6 or 7 Murdaugh and have the jury just be time qualified for 3 weeks and go, I can't be here another week. I have things to do. So they do initial time qualifications for the jurors, meaning, do you have a trip that you need to take? Do you have childcare considerations or concerns that can't be worked around? Do you have other caregiving issues? Do you have work responsibilities that cannot be otherwise handled? Now, employers can't fire you where you're on jury duty, but if you are not working and not getting paid, that can be a tremendous hardship. Some employers do pay for jury duty, some do not. So it really depends on everyone's individual situation as to whether they are able to sit on a jury. So all of those types of time qualifications will go on. Then they're going to go through, hey, there's a video in this case. And we're going to talk about that when we get into the facts of the case in just a minute. There's a video in this case that's been on the news. It's been widely discussed on social media, on YouTube, on podcasts. Have you seen or heard of that? And then they're yeeting everyone who has already seen things that are going to come in and evidence in the case. So it's not things that are rumors. It's not things that are outside of the case, but it's things that will be used in evidence. But bringing in a jury that doesn't have knowledge of this case, doesn't recognize Sarah Boone, hasn't heard about this case, isn't following it, is important to the defense attorneys in this case, but also the prosecution. So trying to make sure they're not bringing in jurors that have a preconceived notion of a case that's high profile. And especially as you get more local, that becomes more of interest. When things happen in your neighborhood, you want to know, right? And this case has been pending for 4 years. So there's lots of opportunity for jurors to come across information in this case, especially when she was wilding, sending letters to the judge when she was representing herself. It got quite a lot of media coverage. So they are time qualifying jurors, then they're qualifying jurors to make sure they don't know about the case, and then they'll get into the voir dire process. The judge is hoping, per reports from the courtroom, to voir dire a panel of at least 50, and that's when the judge and the lawyers get to ask questions. So because it is taking them rounds of jurors to get jurors qualified, both time qualified and who don't have knowledge of the case, it looks like opening statements might be Thursday afternoon, Friday morning. There's going to be some motions on Wednesday, but then back into voir dire, which is not televised or streamed. So I will be covering that and catching up with the immediate before trial motions and opening statements. But I don't know exactly when those will be yet because, well, jury selection is a process that is always in flux. So you know what you're going to need to do. You already do. You're like, yes, Emily, yes. Lawnerd app will tell us when you're going to go live for trial coverage. Yes. And stay tuned to my YouTube channel because as soon as I know when we are going to be covering opening statements, I will share that on YouTube and on social. Let's do a quick overview of the case now that we've done a quick overview of the jury selection process that they are going through. And it's going to take a little longer in this process because they are letting the lawyers ask questions. Some judges don't. Some judges do. I don't know how you get to know a jury if you don't get to ask questions because that's how things were done in the jurisdiction where I practiced for so long. But in some jurisdictions, the judge just asks all the basic voir dire questions and the lawyers can suggest and submit questions, but the lawyers don't interact directly with the jurors. It goes faster, but as a lawyer, it's kind of like a oh, we don't even get to ask you a follow-up question if we have one. And trust, lawyers have questions always. So it moves pretty fast in some jurisdictions. It's not going to move as fast here because the lawyers will be asking some questions during their voir dire process of about 50 to whittle it down to a total jury of 18. What's interesting for me in Florida is that on this case, and Sarah Boone is charged with a second-degree murder of her boyfriend, they only seat 6 deliberating jurors. This judge is looking for actually a larger panel of alternates, up to 8 alternates, but they only seat 6 deliberating jurors. So it shouldn't take as long as some other cases, but ultimately they will be trying to seat 14 jurors in case there are issues that come up and jurors are unable to complete the trial or what have you. As we get into the facts of this case, there is a video on this case you may or may not have seen. It will come up in trial because Sarah Boone is accused of the second-degree killing of her boyfriend. She says in interviews that they were playing hide and seek and he got into a suitcase and she zipped him in. The suitcase had been in the living room because they were going to donate it because it was broken. And then she told law enforcement that she went to sleep. It seemed, based on subsequent interviews, that the two had been drinking and that she thought it was funny. We know this because after she called police, after police came out and took her cell phone, they searched it and found a video on her phone where he is zipped into a suitcase saying that he cannot breathe, asking her for help, and she is mocking him and laughing at him and laughing about the situation, and then she leaves him there. So this is charged as a second-degree murder because she chose to leave him there in the suitcase knowing that harm could come to him, but they're not charging that first-degree premeditated intention to kill. She did call law enforcement. She did tell them in her initial interview that she had been drinking and she went upstairs and she thought he would just get out of the suitcase somehow. So we are going to see that video and all of that evidence and all of her interviews come in. And when I say all of her interviews, she gave an initial interview to police and then went to the police station the next day prior to her arrest and gave a more thorough interview. And we did see her testify recently in a motions hearing, trying to suppress that second interview. And when she testified on the stand in that hearing just a few weeks ago, she said that she was incredibly hungover when she was talking to police. And she talks about the fact that she was intoxicated. Police also interview her son's father, her ex, who talks about the fact that her drinking had become a substantial problem, not just in their relationship, but a substantial problem in her caregiving for their child. And he wasn't always sure if she was going to make it to pick up and things like that. And that there had been relational issues between her and the victim, in this case, her boyfriend. The defense is going to try to lean into that at trial. They have said and given notice that they want to argue a self-defense claim based on a battered spouse syndrome. In the vernacular in Florida, the defense attorney is still calling it battered wife. You will hear it called multiple things. There is updated terminology to that. That's not what's going to be used in this trial. However, you're going to hear them talking about battered wife syndrome, though certainly that is not the most modern phrasing of it. But the self-defense based on her ongoing fear of him is what the defense is going to argue, saying somehow she was afraid and this was intentional. She meant to defend herself by leaving him in the suitcase, which goes against everything that she said in her interviews, where she very much says that they were messing around, that everything was good, that they were having a fun night, and that she fell asleep and this was a complete accident. Her statements to police and the defense attorneys have given notice of, are not congruent. And that's going to be a challenge as we go through this trial to see how the defense tries to navigate all her statements that this was an accident and that this was them messing around and that she was drunk, versus this was intentional and she was in fear for her life, which is not what she says in any of her statements to law enforcement. So as we get through trial, I imagine that we will see her testify. We have seen her be incredibly involved in her defense. And if you've heard of this case, you might have heard that she went through 8 appointed attorneys. Some of those attorneys she worked with, some of those attorneys were given the case and immediately had conflicts, but she went through 8 state appointed attorneys before the judge said, you know what? If you can't work with the state appointed attorneys and you're going to keep writing letters, she was represented writing letters to the judge saying, this attorney's an idiot and this attorney's doing that and this attorney's not attentive, and, you know, just laying it out on her attorneys. And the attorneys are like, yeah, there's nothing I can do. You're not my only client. You're not the one paying me. I've been appointed to you. The judge said, you have reached the limit of the requirement that we provide you with counsel if counsel cannot be afforded. You have tested the limits and found them. So you are now deemed to be self-represented. And then we saw numerous motions where she came into court trying to gaslight the judge, saying, but Your Honor, they did this. And he's like, actually, in the record, this. Because this happened in February of 2020, the court has had a very long time to see Sarah Boone before the court. This case has been continued for trial somewhere upwards of 16 times. It seems that the working relationship with her attorneys had been difficult. As a self-represented individual, she was also difficult with the court, telling the court things that weren't always what the documentation was showing, and sometimes telling the court things that were accurate and winning her motions. So she didn't fare terribly self-represented, but then she wrote a letter to the court, and in that letter to the court, because she seems to be hyper aware of the publicity of this case, it's something she's brought up in court and brought up in her letters. She wrote an advertisement for a lawyer that actually worked, because the attorney that is now representing her volunteered as tribute to represent her based on this letter. I was stunned. So we're going to take a look at the advertisement for a lawyer that she included in her letter to the court, being savvy and aware enough that everybody was going through all of these documents and that the media would pick it up and would disseminate her advertisement for a lawyer for her, literally free advertising, because the media has been covering this case so much. And she 100% used that to her advantage. She seems thrilled with her new attorneys, or at least thrilled that there's somebody in court to talk to her. She also seems to want to run a lot of her defense herself, which I imagine is going to become a power struggle in court. And we're going to talk about that after we take a look at this advertisement. I should be clear. This is not a word from our sponsors. Thank you to all our sponsors who allow us to do the deep dive podcast episodes that we do, but this is her advertisement. This is her filed and handwritten advertisement that says, inmate seeks attorney. And when I say this is written better than most high school kids running for like student council, it is definitely styled. Graphic design is passion. And it says at the top, inmate seeks attorney, looking for a prosperous challenge. How are we determining prosperous? I have questions. Looking for a prosperous challenge, ready for your close-up on national television. National, by the way, is abbreviated so it fits. Are you zealous with a side of keen? Show the world who you are with your original creativity, extraordinary expertise, and confident ingenuity. Qualifications must include, and these are all starred, being trustworthy, honest, passion-driven, open-minded, exceptional problem-solving skills. I mean, yes, exceptional problem-solving skills, and I would say people skills. Oh, that's next. Client inclusion at all times, team orientation, collaboration. I want you to talk to me all of the time. I want to be your only client. I mean, I don't have the money to pay to be your only client, but I want to be your only client. I want all of your time and attention on my case. It goes on to say extreme efficiency in listening. I'm not surprised by this, given that it seems that she and her other lawyers did not see eye to eye on things. And I think that the other attorneys were listening and maybe telling her things she didn't want to hear, because the defense attorney's job is to be up front with their client and tell them what the odds are, to tell them what they're facing, to tell them what their case looks like. I don't know if when she's saying effective listening, she means hear what I'm saying and agree with me versus hear what I'm saying and tell me what I want to hear, as opposed to hear what I'm saying and tell me what I don't want to hear. So extreme efficiency in listening, communicating, understanding, dedication to success, possessing a winning mindset. She's going to girl boss her way into an attorney and possibly prison. Capability of excellence in representation, committed. Maintaining faith in the client and case with the ability to think differently, overcome all circumstances. Ma'am, there's video that, as much as people want to think differently, is going to be real tough to overcome when it is in front of a jury. And then at the end, it says epic opportunity awaits, but each word is separated by a star, lots of stars. But epic, I think that's the right tonality for how it's written. Epic opportunity awaits. So this advertisement of, are you ready for your 15 minutes of fame? And are you zealous? Actually is what landed her with the attorney that she has now. He has said in media interviews that he saw this and fervently believes that all clients should be afforded an attorney, that the fact that she was deemed to represent herself, not by choice, but was forced by the court to represent herself, he thought would be a miscarriage of justice, and came into the case quite late. This ad was filed as part of her whole letter to the court on July 18th, 2024. This case was set for trial October 7th and was going to go to trial come literally anything but a hurricane. And this attorney came into the case with little more than a month to go after seeing this. And in media interviews said he and Sarah had like a knockdown, drag out screaming match and then found a way to come together. I think the way that they came together was, you're completely fucked without an attorney, right? I mean, you might be kind of fucked with an attorney, but without an attorney, good luck to you, ma'am. And I think maybe the reality of what it was like representing herself changed how she chose to work with this attorney, and that maybe those weeks of representing herself illuminated to her the difficulty of doing so, because she maintained every time she came to court, I don't want to represent myself. I want an attorney. And the court's like, we're not appointing another attorney for you. You've had 8 opportunities. That's more than most. So it's going to be very interesting to see what happens in this trial. I will not be surprised if she stands up mid-trial and tries to fire her attorney and ends up representing herself anyways. She is a defendant who, when I look at everything that's happened in this case, I'm like, she is going to testify. She's going to have to testify. If she wants to present the defense that her attorneys have noticed, she is going to have to testify. So it will be interesting to see what happens from here. But she is an interesting defendant, and we are going to see all of her police interviews as we go through this trial. So I will be covering this gavel to gavel, and we will see what happens with Sarah Boone and her attorneys and the 6-person Florida jury as this gets started in Orlando. So if you want to watch along with me, I enjoy trial. I enjoy seeing how the attorney's attorney, from the few motion hearings that I have watched, as I've been keeping an eye on this case, the judge is completely no bullshit. The judge is like, nope. We are not doing that. And I think the judge has been really fair, but really firm in this case. So we'll see how that goes. We love a fair but firm judge. He's been consistent, and the prosecution already seems over it. So to round that out, before trial started last week, Sarah Boone was offered a plea deal by the prosecution to a lesser charge, a manslaughter charge, and offered 15 years on that manslaughter charge. She has already been in custody since February of 2020, so she has quite a lot of time served credits at this point. and she denied that offer. I broke down that hearing and just that small colloquy on Quick Bits this week, but she is facing 22 and a half years minimum to life maximum on the second-degree murder charge if she is convicted of that. So, Sarah Boone, starting trial with opening statements Thursday, optimistically, maybe Friday. Stay tuned and we'll see. Now, someone that has a trial date but's probably not going to see trial on their first trial date. We need to talk about Diddy again. Thank you to our sponsor, Thrive Causemetics, for releasing their holiday shades of the Brilliant Eye Brightener. This is the makeup I refer to as crayon makeup because I wear it every single day and it keeps it simple. But the Brilliant Eye Brightener is what I use not just to highlight my brows, but also for my everyday eyeshadow. And when I'm feeling sassy, I will pick a more shimmery color for an evening out. It's literally the eye makeup that goes in my makeup bag everywhere I go. And their new limited edition holiday glitters are beautiful. Plus, they released a stunning matte black, which is going to make all of my holiday smoky eye dreams come true. So if you are ready for a little bit more to your fall makeup routine, it is time to check out Thrive Causemetics, luxury beauty that gives back. Right now, you can get an exclusive 20% off your first order at thrivecausemetics.com/Lawnerd. That's Thrive Causemetics, CAUSEMETICS.com/Lawnerd for 20% off your first order. Let's get back to today's episode. You may have seen the headlines that there are 6 new civil lawsuits against Sean, Diddy, Puff Daddy, Combs. Yes, there are. I am going to give you an overview of those 6 cases. These are 6 plaintiffs from Attorney Busby's law firm. Attorney Busby is the Texas attorney that held a press conference and said they had received over 3,000 calls of people discussing interactions with Sean Combs. He said that he anticipated bringing up to 120 civil lawsuits. So I'm going to talk to you about what these 6 lawsuits entail. We are not going to get into all the details. If you look at headlines on this case, you can't escape some of those details, but they are, they're awful. They're just awful. However, I don't feel that these lawsuits were written to over exaggerate, to over sensationalize. They are written in a fairly factual way. But again, these are civil allegations, though so many of them mirror what we are seeing in other civil lawsuits and the criminal suits, and they discuss that. The beginning of each of these 6 lawsuits is the same. So the breakdown of who Sean Combs is, who these businesses are, the other lawsuits he's facing, the other allegations against him, the pattern of behavior is the same for each of these lawsuits and will be, I imagine, the same or similar for any other lawsuits this firm files. Then they get into each individual plaintiff. All of these plaintiffs are identified by either Jane or John Doe. None of them are identified by name at this point. And they are all suing under the same civil cause of action in New York. They are filed in federal court, but they are all filed under the New York City Victims of Gender Motivated Violence Protection Act. We're going to talk about that act just a little bit. It's been used frequently in the Diddy cases, and we're going to talk about the statute of limitations and why that is. There are a few of these lawsuits that involve other causes of action, but all of them involve that one cause of action that is specific to that New York City code. So we're going to go through that. Diddy's lawyers have also now responded to this before I started recording today in a statement given to Page 6. I'll cover that at the end. So in going through this, as I go through or try to go through everything, I will be overviewing, but not getting into every single detail. The media has covered every detail in these allegations. And as you can imagine, Diddy's lawyers are denying everything. So we're going to go through the overview of the first lawsuit. I have numbered them just based on the order that they were filed. So I've referred to them internally as a 1, 2, 3, 4. That's just based on their case number. The case number that is the lowest to the case number that is the highest is how I'm going to go through them and give you an overview of how each plaintiff knows Sean Combs and roughly what they are alleging, and the overview that was written, because each of these lawsuits contains a thoughtful introduction saying the conduct described herein is violent and shockingly typical of defendant Sean Combs, aided and enabled by numerous individuals and entities. Sean Combs for many years believed he was above the law. He is not. That is the intro to these lawsuits. For each of these lawsuits, there are numerous corporate defendants. And then in a few of these lawsuits, there are additional corporate defendants. There are no other individuals named at this point. Most of these corporations are corporations related to Sean Combs. So the first one that we are looking at is Jane Doe versus Sean Combs versus Daddy's House Recording Inc., CEOPCO LLC, DBA Combs Global, Combs Enterprises LLC, Bad Boy Entertainment Holdings, Bad Boy Productions Holdings, Bad Boy Books Holdings, Bad Boy Records LLC, Bad Boy Entertainment LLC, Bad Boy Productions LLC, and in this first one, Marriott International Inc., and then additional organizational defendants. They call those does. Sometimes you will see those as rows when it is who they are suing, and there is a Jane Doe as a plaintiff, but that is neither here nor there at this moment. So the corporations and the corporate defendants, we are not going to get into all of them. A lot of those are holding companies, so we're just not going to get there. But each case, as this case seeks both compensatory and punitive damages, that is common throughout all of the cases because the section they are suing under allows for both compensatory and punitive damages. All of these involve sexual assault in different ways, which is why we are not going to get into the details of every single case. They say that Combs accomplished the acts, all of the various alleged sexual assaults, by and through a criminal enterprise built on his success as a rapper, record producer, and record executive. Combs is reportedly one of the wealthiest musical artists in the world. Behind the facade of being a 3-time Grammy Award winner, discovering and developing multiple famous musical acts, and ranking on the Forbes list of the highest paid entertainers in the world, there existed something sinister, a dark underbelly of crime, sex trafficking, forced labor, kidnapping, bribery, and prostitution. Combs is a menace to society, women, men, and children. While his wealth has kept him above consequence for years, Combs now faces the awesome power of the American judicial system and ultimately a jury of his peers who will be asked to punish him for the deplorable conduct described herein. And then they go on to describe the different business entities and how those entities were used, where they're headquartered, etc. In each of these lawsuits, they have a section talking about Combs's history. They titled it Combs's Pervasive History of Sexual Assault and Violence. And then they go through other allegations, including the allegations in these cases. They talk about his parties, and they go all the way back to the nightclub shooting in 1999, saying Combs was embroiled in a high-profile case related to a nightclub shooting in New York involving his then-girlfriend Jennifer Lopez and rapper Shine. Combs was acquitted on all charges, though the case remains a significant legal event in his career. They talk about assault allegations, business disputes, and the claims by Cassie Ventura. They talk about the multiple claims of Combs using the date rape drug Rohypnol, or GHB, and they talk about how prevalent that is in a number of the civil lawsuits. And then they list those civil lawsuits which have claim dates back to 1991. So they talk about different victims of Sean Combs who have sued and when they allege these acts to have taken place against them, including the Cassie Ventura lawsuit, the Little Rod Jones lawsuit, the Crystal McKinney and April Lampos lawsuits, and others. They then talk about the September 2024 grand jury indictment against Combs for trafficking, and they talk about the crimes listed out in the RICO charge that include sex trafficking, forced labor, kidnapping, arson, bribery, and obstruction of justice. They say that Combs' long history of violence against women unequivocally establishes that his actions are motivated by gender, both men and women. What will be interesting to see is how New York handles their statute of gender-motivated violence when they are alleging that the gender that is the violence is motivated against is both men and women. I don't know how the code will see that. I imagine Combs's attorneys are going to argue it's not motivated by gender if it is both men and women. So we will see in early motions, I'm sure motions to dismiss, saying that it can't be motivated by gender if it's not specific to a particular gender. So we will see how Combs's attorneys argue that. However, we'll go through what the code section says, but I can see this as an area where the defense might try to argue that this is not what the statute intends. I don't know how successful that will be, because if the actions are taken against a person in a sexual nature, there is room for argument from the plaintiffs that they are being assaulted because of their gender, and that counts as gender-based violence or motivated by gender. So there is going to be some legal wrangling that is going to happen over this New York statute that we will see in the motions going forward from the legal perspective. But what they allege here is that Combs has profound contempt for women and a desire to dominate both minors and men. They say his conduct shows a long-standing practice of denigrating, defeating, and attempting to humiliate men, women, and children. His practices and desires are different for men, women, and children, and his actions are unequivocally motivated by the victim's particular gender and age. So we're going to see that will be a point of argument. But we also see the plaintiffs lining that out, saying the way that men are treated by Combs and the violence motivated against them plays out differently than the violence against women. They go on to say plaintiffs' allegations herein substantially mirror Combs's prior conduct as established through criminal indictments and other lawsuits. Throughout this case, plaintiff seeks a full measure of justice from a man who, through his power, money, and influence, rendered him untouchable. Plaintiff joins many other victims by filing this complaint in hopes their common voice makes it impossible for Combs to assault another person ever again. They do take a moment to say that defendant Sean Combs is a male who, on information and belief, resides in New York City through incarceration in the Metropolitan Detention Center in Brooklyn. So they do list him as incarcerated in all of these. I imagine that part of the reason these civil lawsuits are coming forward now is because he is incarcerated, and there is some measure of maybe hope from the victims that him being incarcerated makes them a little bit safer from him or those around him as they go forward in these lawsuits. I'm going to skip to the first cause of action, and then we're going to talk about the plaintiffs in each lawsuit and how they know Sean Combs and briefly what they allege. But this is consistent, though factually specific for each cause of action. The first cause of action is violation of the New York City Victims of Gender Motivated Violence Protection Act. And they state that by forcing sexual contact onto plaintiffs, specifically by physically assaulting, and then this is varied based on the particular plaintiff, that Combs committed a crime of violence motivated by gender under the Victims of Gender Motivated Violence Protection Act as defined in New York City Administrative Code 10-1103, the requirement that the crime of violence be committed because of gender or on the basis of gender or due at least in part to an animus based on the victim's gender is satisfied because defendant Combs forced plaintiff to engage in sexual interaction without consent. And that is consistent through each of these plaintiffs and each of these lawsuits. And then they talked about what happened in each case, saying that the Combs businesses enabled Combs to commit the crimes of violence motivated by gender by failing to, among other things, protect plaintiff. All of these things happened in situations where business was also intertwined. They further say that the Combs corporations further enabled Combs to commit the crime of violence motivated by gender by actively placing, maintaining, and or employing Combs in positions of power and authority, despite the fact that they knew or should have known that Combs had a widespread and well-known practice of committing sexual assault and gender-motivated violence. Marriott is also named in this first lawsuit, and we will talk about Marriott being named in just a moment. And then the prayers for relief are similar, awarding compensatory damages for physical injuries, emotional distress, psychological harm, anxiety, humiliation, physical and emotional pain and suffering, as well as family and social disruption and other harm, awarding punitive damages to be determined at trial, awarding attorney's fees and pre- and post-judgment interest, and then asking for a jury trial. So as we go through these, I'm going to overview each of these 6 plaintiffs and what they are alleging and when they are alleging. But in talking about when, we need to talk about the statute of limitations real briefly. Most crimes or causes of action have some type of statute of limitations, a time in which you must bring the cause of action or you can no longer bring it. Some things have no statute of limitation, murder being one of them. Some things, the statute of limitation will start when you turn 18 or when you discover something, which is really common in fraud cases. The statute starts running when you discover that the thing has happened. In this statute, there is a carve out for the statute of limitations. So it lines out the statute of limitations and then has an exception at the end. It says, notwithstanding any provision of law that imposes a period of limitation to the contrary, any civil claim or cause of action brought under this chapter that is barred because of the applicable period of limitation may be commenced not earlier than 6 months after and not later than 2 years and 6 months after September 1st, 2022. So to make that not as lawyerly, in general, not later than 2 years and 6 months after September 1st, 2022. So we are seeing these things being filed in October of 2024 because we are going to be getting to the end of the statute of limitations for this particular section of the New York City Administrative Code. Different than some of the other lawsuits. Some of the other lawsuits that were filed, including the Cassie lawsuit, was filed as the other code section was expiring. So under Cassie's lawsuit, she had included this same section that is being included here, but it also included other New York statutes that were expiring at the end of 2022, including the New York Services for Victims of Human Trafficking laws and the commensurate California Act. There had also been a couple extensions of statute of limitations in New York, California, and some other jurisdictions that were expiring at the end of 2023. So that's why we saw some of those lawsuits swoop kind of right at the end of 2023. And now under this code section, we are going to see a spate more lawsuits. Between now and the end of the 6-month period from September of 2024. So hopefully that answers the question of how these are being brought when some of the acts alleged happened quite a while ago. And it's because of those statute of limitations written into the various code sections. So I'm going to get into talking about each of the individual 6 plaintiffs. And of course, if you are watching on YouTube, we timestamp everything down below. I am going to be giving a broad overview of what happened, not the detailed recitation of the things that happened to each of these plaintiffs, which you can widely find in the news media. But if you want to zoom through it, it will be timestamped down below on YouTube for you to do that. And then basically, we will be talking about what comes next. So for case 1, which is the Jane Doe versus Sean Combs that we were reading from, that case also involves allegations against the Marriott because the plaintiff in that case was taken from a party, from a photo shoot and then from a party that she was at with Sean Combs to a Manhattan area Marriott, and the assaults that happened at the Marriott. She alleges in her lawsuit that she and her friend were 19-year-old college students in Brooklyn, New York, and there was an event happening on campus, and she was invited to a photo shoot with regard to a music video that was going on. And then after the photo shoot, she was taken to the Marriott with her friend. They were threatened with violence. They were being given drinks. They were being told to do illegal drugs, including cocaine, and then were threatened after the assault with violence and death if they told anyone. And so as to plaintiff 1, that is why the Marriott is involved. So with regard to lawsuit 1 and plaintiff 1, that's why the Marriott is involved, because that is the location of the assault in Manhattan, New York. Lawsuit 2 is a John Doe versus Sean Combs. There are 2 causes of action in that, including the victims of gender motivated violence cause of action. And then there is an assault and battery with regard to aggravated sex abuse cause of action as well. The plaintiff in that case, John Doe, worked for Royal Reigns Management based out of New York, attended a Diddy party and was picked up by associates of Diddy, was flown out there for the party, was out there to work with Diddy and the various businesses. And once arrived at the party, was offered narcotics, including ecstasy, though plaintiff refused all of the narcotics. But plaintiff was offered a drink and did have one drink and said that he immediately began to feel the effects of that drink within not even completing the drink, and was trying to get away or trying to get to a safe space because felt unwell and unable to control his body. And at that time, Combs and others assaulted him, and he detailed what happened with Combs and others and being left as they all returned back to the party. These allegations mirrored a lot of the allegations we saw in other lawsuits of laced bottles of liquor, which is a common theme throughout a lot of these civil lawsuits, that there were laced bottles of liquor, and some people were given the laced bottles of liquor and some people were not given the laced bottles of liquor. But it is incredibly common to see plaintiffs in these civil lawsuits talking about taking a few sips of a drink or not even finishing a drink and immediately feeling unwell, drugged, and disproportionately impacted by the relatively little they had had to drink. In the third lawsuit, the victim is a John Doe. This lawsuit also includes Macy's as a defendant. This is the one violation of the New York City Victims of Gender Motivated Violence Protection Act. This individual was working as an advisor for Echo Clothing in 2008 and worked there for approximately 7 years prior to that, and had met Combs on multiple occasions with Combs's launching of Sean John clothing. For anyone who was around in the early mid 2000s, you know exactly what I'm talking about as we're talking about Echo Clothing and Sean John. The allegations here happened in a stockroom at Macy's, where plaintiff was blocked into the stockroom and physically and then sexually assaulted. The plaintiff alleges that they reported the assault directly to Macy's security, and shortly thereafter was blocked from coming to the Macy's flagship store where they had been working in their job with Echo Clothing. They allege that 3 weeks after that, the CEO of Macy's pressured the executives at Echo to fire the plaintiff, and allege that that is because Macy's had just signed a multi-million-dollar deal with Sean John Clothing. It is very interesting for me to see that the plaintiff knows these things and that they are starting in these lawsuits to see other companies being pulled into this as companies that were aware of what was going on, were told what was going on, and then as opposed to, calling it out and protecting individuals, they said, no, what you need to do is fire that person. So it will be interesting to see what happens with this lawsuit with regard to Macy's, and if there is a paper trail from 2008, and if the executives at Echo will be involved in saying, yes, this is exactly what happened in this case. And again, I imagine that there will be a paper trail to all of this. The fourth plaintiff also sued for the same violation of the act. This is a John Doe versus Combs. The intro mirrors the other lawsuits that we have seen, but this is a plaintiff that worked for a security firm in 2006 and provided security for private events and nightclubs, and was working at a white party at Combs's East Hampton home. During the event, the plaintiff was provided alcoholic beverages and became extremely ill after the second drink. He was approached by Combs and pushed into a van at the party and was sexually assaulted by Combs. And Combs left plaintiff in the van and returned to the party, and plaintiff then described recovering from the effects of that drink where they felt extremely unwell, again alleging that they believe that the drink was laced, which is a commonality amongst these suits. That is from 2006. The fifth lawsuit is a Jane Doe versus Combs from 1995. Plaintiff had attended a promotional party in New York for the music video One More Chance by Biggie. Combs approached the plaintiff at the party and said that he wanted to speak with her privately, and then led her into a bathroom where he began to forcibly kiss her. She was disinclined to engage in that activity with him at all, and he responded by striking her and knocking her to the floor, and then sexually assaulting her and threatening her with death if she reported it to anyone and if she told anyone. Multiple times. And that, again, is a theme in these plaintiffs' suits, that there were threats of death, violence, I'll make you disappear, and the rest of it. And when you look at the timeline that this was happening, where he was incredibly powerful, it does not surprise me at all that all of these plaintiffs were like, and I believed it. And I absolutely believed that when he said that that's what was happening or would happen, that that would happen. The final lawsuit is one you have probably seen on the media quite a lot. This one includes a photo of Combs with the victim at a white party. The victim's face is redacted for their privacy. This is also filed as a John Doe versus Combs. This victim was 16 at the time that he went to Sean Combs's white party in 1998. The victim in this case, and I believe shared the party to illuminate for the court, not only have these victims been vetted, but there is documentary evidence of their interactions at these times with Sean Combs. The victim detailed that the reason he went to the party is because he wanted to break into the music industry, and Combs was talking to him about the music industry, saying that he had the look. And when the plaintiff is detailing that conversation, the plaintiff stated to Combs he wasn't sure if he had the talent, and Combs said, quote, he could transform anybody into a star, and told the plaintiff that because he had the look, that was really all that mattered, and then told the plaintiff that he needed to drop his pants, expose himself, and he was then assaulted by Sean Combs at the party. And then afterwards, Combs said his people would be in touch and walked away as if nothing happened. So as we get into these lawsuits, this is the first lawsuit that has allegations from someone who was a minor at the time of the lawsuits, though other lawsuits have illuminated to the fact that they believe there were minors at the white parties and others. This is the first lawsuit with a minor bringing the lawsuit. And these lawsuits, the way we see the Cassie Ventura lawsuit being brought into the federal indictment, these are lawsuits and individuals that can, if they choose to, speak to the feds, that can become part of the RICO allegations, because the RICO allegations in this case might mirror to some of you the R. Kelly RICO allegations, using the businesses as part of the threat of force or fear, using that as part of the ongoing pattern of behavior, because that is what's allowing Sean Combs the access to these victims that have brought forth all of these lawsuits. These are somebody who came across Sean Combs because of work in the fashion industry. That's one of his businesses. Because they were at a release party for a Biggie music video, because they were at his white parties, because they wanted to be in the music industry. So we're seeing again and again the businesses being pulled into this because it is how he has access. It's also how he is protected. That is very similar to what we saw in the R. Kelly use of the RICO case to go after businesses that are operating with, criminality. So as the civil lawsuits continue, and I expect we will see more of these civil lawsuits with different plaintiffs, with different interactions of Combs that kind of echo what we've seen so far, I wonder how many of those we will see get pulled into either the RICO charge or be brought as individual charges in superseding indictments against Sean Combs. We can see superseding indictments against Sean Combs. The feds can choose to bring any of these victims in if they have the evidence to meet their filing standards as additional victims, or they can bring them in under the RICO case as predicate acts to make the RICO case. So the feds have a lot of options in how they choose to do this and how they choose to move forward. But when the trial date got set for Sean Combs on May 5th of next year, 2025, I think we'll see superseding indictments before then. And I don't think we will see the trial starting when they say it's going to start, especially as the feds are going through all of the video and are seeing individuals, especially from the white parties, at these parties. It's going to give them the corroboration that they need to bring these either under the RICO or bring them as individual charges. So we will see what happens with Sean Combs, but the fallout is not limited to him at this point. And I say that because we're also seeing allegations in an ongoing lawsuit against Kanye West. There has been an ongoing employment law lawsuit in Los Angeles against Kanye he's got a lot of lawsuits at the moment from a former employee. And that lawsuit had included sexual harassment claims as well as wrongful termination claims. But in an amended complaint to that lawsuit, the plaintiff has alleged that during a studio recording session with Kanye West and Sean Combs in Santa Monica, California, she was served drinks and immediately began to feel ill, confused, and like she didn't have control of her body or speech. She alleged in that amended complaint that she felt that she had been drugged and that she did not know what happened that night until years later when Kanye West brought it up and said that they did kind of hook up that night and then told her about the night that happened. So we have seen a new filing in that ongoing lawsuit against Kanye West regarding an evening with Kanye West and Diddy. So if you're interested in that lawsuit that is ongoing in California, let me know and we can break it down a little bit more. But we're not done yet with the ripples these lawsuits are going to cause. We are at the beginning. Of course, we have to talk about what Combs's lawyers have to say. I mean, lawyers are going to lawyer, but this is not the place you want to be in as the legal team. If you're looking to take your e-commerce or in-person sales to the next level, today's sponsor, Shopify, has you covered. Shopify is the platform I run the Law Nerd Shop on, and you're going to see a whole lot more of that in the coming weeks as we have some exciting things for you coming to the Law Nerd Shop. I made the Law Nerd Shop on Shopify because it is the easiest platform to use, but also it has one of the best converting checkouts on the internet. So I knew that there wasn't going to be frustration on your end, whether you're buying your favorite nail polish or your favorite fax hat. And Shopify offers Shop Pay, which makes it easy for your customers to check out. And as a shopper, it makes it real easy for you. It's no wonder the businesses that grow with Shopify. So if you're ready to upgrade your business and get the same checkout that the Law Nerd Shop uses, you can sign up for your $1 per month trial with Shopify at shopify.com/lawnerd. Remember, that's all lowercase. Go to shopify.com/lawnerd to upgrade your selling today with a $1 per month trial period. That's shopify.com/lawnerd, and you're going to start hearing this sound soon. Let's get back to today's episode. Everyone deserves a defense. However, I imagine that is harder to provide for some than others. I did not work as a defense attorney, so I do not know. This statement from Combs's legal team comes to us through page 6, which is who the statement was provided to. Attorneys for the incarcerated Act Bad rapper slammed the newest victim's lawyer, Tony Busby, over the, quote, barrage of lawsuits he filed against the rapper on Monday. They said, quote, the press conference and 1-800 number that preceded today's barrage of filings were clear attempts to garner publicity, the lawyers told Page 6. They continued saying, quote, Combs and his legal team have full confidence in the facts, their legal defenses, and the integrity of the judicial process, In court, the truth will prevail that Mr. Combs has never sexually assaulted anyone, adult or minor, man or woman. So for the lawyers for Sean Combs, they say this is a clear attempt at publicity, but I guess it's a step better than their constant attacks on Cassie Ventura, and it sticks to talking about the lawyer. So maybe we're seeing some improvement. However, we'll let the facts play out in court is all they're going to be able to say. What I am interested to see in these lawsuits is, will the attorneys be filing to kind of delay these suits until after the criminal proceedings are complete? Or will a separate set of attorneys be moving forward on the full breadth of the civil cases, of which there are over a dozen at this point, and let the criminal team work on the criminal cases? But Sean Combs is going to be spending not only his time in custody, we will see if the Court of Appeals in early November is what his team is asking for, decides that he is allowed out of custody. I don't think that is likely at all. But he will be fighting lawsuits on multiple sides. And I imagine his lawyers will try to use that as a reason that he can't be incarcerated, arguing, look, Your Honors, and I say Your Honors because this is going to be in front of a 3-judge panel at the Court of Appeals, but look, Your Honors, he is fighting a unending, quote, barrage of lawsuits, and he cannot adequately defend himself on the criminal side or the civil side from in custody. It is simply too much. And him being in custody has brought forth a wave of civil lawsuits. And in the last argument regarding bail that they argued this, they said that the indictment and the civil lawsuits opened the floodgate. Their words were of people looking for a check. I imagine that we will see a similar argument from them when they argue bail again. However, I imagine what we will see from the government again is that the power and the wealth and the accessibility to victims and potential witnesses in this case is absolutely a reason he should stay in custody, and that the law assumes that he stay in custody, and it is on him to prove that he should be out of custody. And they're going to continue to argue the Sam Bankman-Fried case, where he was put into custody after being out of custody because he was leaking information to the New York Times, even though he had incredibly restricted access while he was out on home arrest. So even though he was out on home arrest, he was still able to use the New York Times to attempt to intimidate one of the government's main witnesses. So we're going to see those arguments come again in front of the appeals court. The date has not yet been set on that, but as it is set, I will let you know in the Law Nerd app. I will keep you posted. We will be in the Sarah Boone trial for the next few weeks once a jury is selected, and I hope to see you there. I very much anticipate moving to other cases for the next few weeks. These civil lawsuits will continue. We know that from Attorney Busby out of Texas, that there will be more of these suits and they will continue. Now that we have seen the first 6 and we see what code section they are using, I imagine the cases that will come after those will have similar intro allegations, similar cause of action, and then we will get specific facts as to each plaintiff under either a Jane Doe or a John Doe status, and that we will see quite a few more of them. So with that, thank you. I'm sure I've repeated myself quite a lot in this episode, and I appreciate your patience with my very tired brain. And I appreciate you for being here and for being a law nerd. I hope it is starting to feel like fall where you live. It is definitely starting to feel like fall here in Middle Tennessee. And with that, thank you for being here. And thank you for being a law nerd. I should say, may your Wi-Fi be strong. May your toilet paper be plentiful. May your family be well. And may the odds be ever in your favor. See you in the next one. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a law nerd.